American Advantage Law Group is proud to bring you this webinar for your legal enjoyment. Bankruptcy. What do you need to know? Why declare a bankruptcy? It puts a stop to creditor harassment. Once the debtor files for bankruptcy, the automatic stay prevents the creditor from contacting the debtor or attempting to collect on most debts. Within 3 to 6 months, many of the debtor's obligations will be discharged. Costs include approximately $270 in court fees and an additional amount in legal fees. Which debts will bankruptcy discharge? Bankruptcy discharges claims. Claims include every possible debt the debtor owe or might owe in the future based on the events leading up to the day of filing for bankruptcy. It is always better to be over-inclusive in paperwork than to leave out a claim, because bankruptcy will not erase any claims that are omitted. Credit card issuers often challenge bankruptcy filings for debtors who have charged luxury items totaling at least $500 to one creditor within 90 days of filing, cash advances totaling at least $750 from one creditor within 70 days of filing, and any debts they claim that the debtor never intended to repay anyway. These challenges require the debtor to prove the existence of a feasible plan to repay the debt at the time it was incurred. Bankruptcy will not erase debt arising from child support or alimony, divorce property settlements, student loans, government fines, penalties, and court-ordered criminal restitution, tax debts, court judgments stemming from injuries or deaths caused by drunk driving or intentional torts, or debt incurred on the basis of fraud. How does bankruptcy then proceed? The debtor's finances are put in the hands of a court-ordered trustee. The trustee is an official appointed by the court to process the bankruptcy. It is his or her job to find the property belonging to the debtor to sell for the benefit of the collectors. After filing, the debtor cannot sell, give away property owned at the time of filing, and pay for pre-filing debts without the trustee's consent. The debtor has one meeting with the trustee where the trustee asks the debtor questions about the information on the bankruptcy forms under oath. Automatic stay. The way that it works is it impacts different facets of payments. In utility disconnections, they're stopped for at least 20 days, and bankruptcy is likely to discharge the debt. In foreclosure proceedings, they are stalled but eventually proceed. In evictions, if the landlord has already obtained a judgment, then there is no stay. But if there is yet to be a judgment obtained, the proceedings will be stalled but will eventually proceed. For public benefits overpayment, it stops the collection from current checks. From child support or alimony, there is no interruption or obligation. From divorce property settlements, obligation will be interrupted, although it will eventually resume. Wage garnishments are stopped completely. Once the bankruptcy settlement is discharged, collection amounts may be recovered by the debtor if not already turned over to the creditor. Secured creditors. If a secured creditor is undersecured, meaning that the value of the collateral is less than the outstanding value of the loan, the stay can be lifted on the creditor and they can repossess if the debtor is behind on payments. But if the stay is lifted, recovery is limited to the value of the collateral. Any additional amount is unsecured and usually discharged in bankruptcy. Who cannot file for bankruptcy? Anyone who has not lived in California for at least 20 months. Anyone who has completed a Chapter 7 bankruptcy proceeding within the last 6 years. Anyone who has filed for Chapter 7 bankruptcy within the last 180 days where the bankruptcy was dismissed because of a violated court order, or because the debtor requested the bankruptcy dismissed after the creditor lifted the automatic stay. If the debtor has any required paperwork, is missing any required paperwork, the case may be dismissed automatically. If the debtor's case is automatically dismissed and he or she files again within 1 year, the automatic stay only lasts 30 days unless the debtor can prove the second filing was in good faith. If the debtor's case is automatically dismissed for a second time, there is no automatic stay for a third time unless they can prove the same.